All right, let's go. The man sitting across from you has 3 counts of racketeering, 1 count of conspiracy to commit murder, and a cup of coffee that he stirs counterclockwise without looking at it, and he wants to know if you can get him out. That's the room. That's always the room. Not the courtroom. Everyone pictures the courtroom. The courtroom is the end of the story. The room is a visiting suite in a federal detention facility at 7:40 in the morning, and the man across from you is not scared, and that is the first thing you need to understand about this job. They are never scared. Scared people hire scared lawyers. These men hire you. And you, 3 years out of Fordham law, billing $240 an hour, and carrying a briefcase that cost more than your first car, have just looked at the indictment on the table between you and understood, on a cellular level, that the government's case is not as clean as they want your client to believe. You open the folder, you pick up your pen, you begin. This is a top 10 countdown, 10 entries, 10 dimensions of the life you chose when you took that retainer, and you did choose it. That is the thing about this job that every defense attorney who has ever done it understands by the end of the first year. Nobody drafted you. The phone rang and you answered. Now let's count down what you answered to. 10. The first retainer. The room you just walked into. It is 1974, and you are a 31-year-old associate at a mid-sized criminal defense firm on the 7th floor of a building in Lower Manhattan, and the senior partner calls you into his office on a Tuesday afternoon and tells you that a client needs a second chair for a bail hearing on Friday. The client's name is on a yellow sticky note on the partner's desk. You recognize it the way you'd recognize a weather system, not from personal exposure, but from what it does to the air when people talk about it. The partner tells you the hearing is straightforward, that you'll be doing nothing more complex than sitting at the table and handing documents, that this is how junior associates get introduced to this category of client. He uses the phrase "this category of client" as if it were a practice area like tax law or patent litigation. You take the sticky note. You do not ask what the charge is. That is the first thing you do that is not routine. What you noticed. The bail hearing is before a federal magistrate in the Southern District. There are 4 other men in the gallery, not press, not family, not observers in any recognizable sense, and they sit in the second row and they do not take notes and they do not speak, and when the magistrate enters, they stand with the same timing as everyone else. Your client is brought in through the side door wearing a suit that someone brought to the facility the previous day. The suit fits. That is a specific kind of detail. Someone knew his measurements. Someone had them already. The senior partner argues the bail conditions for 11 minutes. He has argued this before, not this case, but this shape of case, and his fluency with the language of it is its own kind of information. Your client is granted bail in the amount that required a man to make 2 trips from the parking structure to the clerk's window. The detail nobody in that room could account for cleanly was the 4 men in the second row, who stood up when it was over and left without speaking to each other. What got out and what didn't. The bail hearing was a matter of public record. The docket entry noted the amount, the conditions, and the attorneys of record. A brief item appeared in the next morning's paper, 2 paragraphs, buried in the metropolitan section, describing the bail grant as routine in cases of this type. The FBI's surveillance log from that date, portions of which were later released in discovery in a separate proceeding, noted the presence of 4 individuals in the gallery and identified 3 of them by name and organizational affiliation. The newspaper did not note the 4 men. The FBI log did not note that one of them had nodded, barely perceptibly, at your senior partner as they passed in the corridor after the hearing. People in the corridor reported it. The log did not contain it. How it was closed. The bail proceeding was duly entered into the record of the Southern District of New York. The defendant complied with the stated conditions of his release and appeared at all subsequent proceedings as required. The case proceeded through the normal pretrial process. No disciplinary inquiry was initiated regarding the conduct of defense counsel. The representation was entirely lawful. This is not a minor point. It was, in every formally accessible dimension, entirely lawful. The thing that doesn't close. And yet the senior partner, when you handed the sticky note back to him that Friday afternoon, did not put it in the file. He held it for a moment, then folded it once and put it in his jacket pocket. That is a physical gesture. You saw it. A sticky note, folded once, disappearing into a jacket pocket, that is not a filing system. That is a different kind of record keeping, one that does not interface with the district court's docketing software or the firm's billing system. Across the next 3 decades, you will watch roughly 40 attorneys of your acquaintance navigate this category of client, in 7 cities, in 4 jurisdictions, and the ones who last the longest share one habit. They develop early a very precise understanding of what goes in the file and what goes in the pocket. That distinction, applied consistently over 30 years, is the difference between a career and a cautionary tale, and the line between them is thinner than the fold in a sticky note. 9. The hourly rate. The room you just walked into. It is 1979, and you have your own practice now, 3 associates, a paralegal, an office on the 14th floor with a window that faces east and catches the morning light in a way that you chose it specifically for, because you made enough in the previous 5 years to choose things specifically. The firm's books, if a billing auditor were to examine them, would show a client roster of approximately 60 active matters. Roughly 12 of those matters generate 80% of the firm's revenue. The 12 are all, in one form or another, within the same gravitational field. You did not plan for 12 to become 80%. You planned for a diversified criminal defense practice. What happened instead is what always happens. You were good at the work, and word moves in a straight line among people who need the kind of help you provide. A man named Salvatore Lombardo, not a figure whose name appeared in any public record at this time, but whose organizational position was understood by anyone in the relevant professional community, sat in your client chair in October and asked you to put him on retainer. He placed an envelope on your desk. He did not slide it. He placed it with both hands flat, the way you place something that has earned respect. What you noticed. The envelope contained a cashier's check. The amount was sufficient that, when you handed it to your bookkeeper, she looked at it and then looked at you and did not say anything, which was its own kind of answer. Lombardo was represented at the meeting by a man who sat to his left and who spoke only once to confirm a date, and who wore a watch that cost more than the retainer. The retainer covered 60 days of access, meaning Lombardo or his designated representatives could call your direct line at any hour and you would answer. Not the answering service. You. This arrangement was not written into the retainer agreement in those specific terms because the retainer agreement was a document that would exist in a file, and the specific terms of availability were an understanding, not a document. Lombardo shook your hand at the end. His handshake was brief and complete. The detail no one in the room had a clean answer for was what, exactly, the 60 days of access was anticipating. What got out and what didn't. Defense attorneys are not required to disclose the names of their clients in most circumstances, and attorney-client privilege is among the most durable legal protections in the American system. No public record of the retainer existed. What existed, in the FBI's files at the field office level, was a notation in a running surveillance log that described a vehicle registered to an individual associated with Lombardo's organization making 3 visits to your building in a 10-day period. The log did not note what business was conducted. It noted the vehicle, the dates, and the duration of each visit. What people in adjacent professional communities are other defense attorneys. Former prosecutors who had moved to private practice understood was that a retainer of this type was not primarily about the 60 days. It was about the signal. The signal was that you were available. Available in this context is a word that carries more weight than its syllables suggest. How it was closed. The retainer was recorded as income on the firm's quarterly filing. Applicable professional responsibility rules regarding the receipt of fees were complied with to the satisfaction of all relevant oversight bodies. No disciplinary proceeding was initiated. No inquiry was made by the relevant bar association. The representation, as documented, was a lawful engagement for criminal defense services. The 60 days passed. Additional arrangements followed, documented similarly in subsequent quarters. The thing that doesn't close. But Lombardo placed the envelope with both hands. That is not how you hand someone a check. That is how you hand someone a thing you want them to understand the weight of. And the weight was not the number on the check, though the number was real and it mattered. The weight was the relationship being formalized, the specific gravity of being the person that a man like Salvatore Lombardo calls when the 60 days produce what the 60 days were anticipating. By 1985, your direct line number was in the possession of individuals across 4 states. You did not give it to all of them directly. It moved the way information moves in that world, in a straight line, from the person who needed it to the person who needed it next. The line, if you drew it on a map, would cross 12 cities and span, in its full extension from the first retainer to the last recorded call on that number, 22 years. 8. The first time the government came for you. The room you just walked into. It is 1983, and there are 2 men in suits standing in your reception area at 9:15 in the morning, and your receptionist has called back to your office using the specific tone she uses when she wants you to know, before you walk out, that whatever is in the waiting room is not a client. The 2 men are from the Department of Justice. One is from the Criminal Division. One is from the Office of Professional Responsibility. They have a subpoena. The subpoena is for billing records, communication logs, and retainer agreements for a list of named clients that runs to 2 pages. They present it with the particular precision of people who have been told by their supervisor to be precise, which means they are not the ones who decided to do this. Someone above them decided. They are delivery. You take the subpoena. You hold it with one hand at your side, and you tell your receptionist to get your partner on the phone. You do not invite the men to sit down. What you noticed. The subpoena is issued out of the Southern District, signed by a judge whose name you know and whose judicial temperament you have a detailed internal file on. The 2-page list of named clients represents, by your rapid count as you read standing in the hallway, roughly 7 of the 12 matters that constitute your firm's primary revenue. The Criminal Division attorney, Younger, the one who made eye contact when he spoke, has a briefcase with a combination lock, which means he is carrying additional materials he has not presented. The OPR attorney is older and does not make eye contact, which means he has done this before and has learned that eye contact complicates these interactions. You have 11 days to respond. 11 days is not a short window. It is a deliberate window, long enough that you cannot claim emergency, short enough that you cannot be leisurely. The detail nobody in that hallway had a clean answer for was what the government actually had, as opposed to what the subpoena was designed to find. What got out and what didn't. A brief item in the legal press noted that a subpoena had been served on a prominent criminal defense firm in connection with an ongoing organized crime investigation. The item did not name the firm. It characterized the subpoena as a document production request, which was accurate as far as it went. What the DOJ's internal communications, portions of which emerged in subsequent litigation over the subpoena's scope, described was a theory that certain billing arrangements between the firm and specific clients constituted knowing participation in a money laundering scheme, in that fees paid from proceeds of criminal activity and recorded as legitimate income were, under the relevant statutes, themselves criminal transactions. The legal theory was aggressive. Several former prosecutors, consulted by the press off the record, called it a reach. The government called it a good faith interpretation of the statute. How it was closed. The subpoena was contested through appropriate legal channels. A motion to quash on attorney-client privilege grounds was filed in the Southern District and argued before the relevant magistrate. The motion was granted in part, and denied in part. Documents produced pursuant to the court's order were reviewed by the investigative team. Following review, the Department of Justice declined to bring charges against any attorney or firm employee in connection with the matter. The declination was communicated by letter. The letter noted that the decision did not reflect a finding that no violation had occurred, but rather a prosecutorial judgment regarding the sufficiency of available evidence. That specific language does not reflect a finding that no violation had occurred, was not quoted in any press account of the declination. The thing that doesn't close. And yet the letter is in a file in your office. You have read it, by now, enough times that the paper has developed a softness at the fold lines. Does not reflect a finding that no violation had occurred. That sentence is not an accusation. It is not a conviction. It is not anything a bar ethics panel can formally act on. It is a sentence that occupies a specific negative space, the shape of what they couldn't prove rather than what you didn't do, and it sits in that file across the next 19 years without resolving into either acquittal or indictment. Roughly 240 attorneys were investigated under similar theories during the federal government's organized crime prosecution push of the 1980s. Charges were brought in 11 cases. Of the 229 for whom they were not, the letter they received used, in most cases, nearly identical language. 229 letters, sitting in files in offices across 6 jurisdictions, each one a document that says nothing and means something. Before we cross into the top 7, the subpoena was the test. Every attorney in this world faces some version of it. The ones who get to number 1 on this list are the ones who understood what it was testing for, and it was not what the government said it was testing for. 7. The client you knew was guilty. The room you just walked into. It is a Tuesday in February 1986, and you are seated at the defense table in a federal courtroom in the Eastern District of New York, and the man to your left, your client, a man named Carmine Russo, whose indictment runs to 41 pages and includes 17 specific overt acts in furtherance of a conspiracy, is writing something on a legal pad. You cannot see what he is writing. You have learned, over the past 11 months of representing him, that what he writes during proceedings is never notes about the proceedings. He writes other things, things that have nothing to do with the trial. He wrote a grocery list during the suppression hearing in September. He wrote what appeared to be a birthday card during the government's opening statement this morning. The jury is listening to the AUSA describe, in specific and accurate detail, an event that you know because your client told you, in the privileged space of the attorney-client relationship, occurred exactly as described. You are sitting still. That is the entire job in this moment. What you noticed. The AUSA is a woman named Patricia Hennessy, and she has been in the Eastern District for 7 years, and she has the jury's attention the way a person has attention when they are telling the truth and the room can feel it. She describes a meeting. She names a restaurant. She gives a date in March 1984 and a time in the early evening and a table in the back, near the kitchen, where the noise from the kitchen covered the conversation from the adjacent tables. She describes who was present. She is accurate about the table. She is accurate about the noise from the kitchen. She is accurate about who was present. Your client continues to write on the legal pad. He does not look up. His pen moves in a small, controlled way, not the gesture of a man agitated. Not the gesture of a man composing his defense. Just someone writing. The detail no one at the defense table could answer cleanly was how Hennessy knew about the noise from the kitchen, because the informant the government disclosed had been seated at a table near the front. What got out and what didn't. The trial proceedings were a matter of public record and received moderate press coverage. The government's case was described in the press as circumstantial but detailed. Defense counsel was quoted in a brief sidebar with a reporter during a recess, as describing the government's case as reliant on the testimony of a compromised witness whose credibility would be thoroughly examined. This was accurate. What the press did not report and what the public record did not contain was the conversation you had with your client in the holding room the previous Thursday, in which he told you, with the same affect he uses to order lunch, what had occurred at that table in March 1984. He did not tell you because he trusted you with the information. He told you because he trusted you to understand that the information did not change your job. And he was right. It did not change your job. It changed something else, something with no name in the model rules of professional conduct, and you have been sitting with that change at the defense table for 11 months. How it was closed. The jury returned a verdict after 3 days of deliberation. The verdict on the primary conspiracy count was not guilty. 3 of the lesser counts resulted in guilty verdicts on reduced charges. Sentencing was conducted 4 months later. The sentence on the reduced counts fell below the guideline range, a result attributed to specific statutory factors argued by defense counsel at the sentencing hearing. The representation was lawful. The verdict was lawful. The sentence was lawful. No judicial finding was made regarding the accuracy or inaccuracy of the government's account. The case was closed by the court. The thing that doesn't close. But Hennessy knew about the noise from the kitchen. And you don't know, to this day, how she knew. The informant was seated near the front. The FBI surveillance noted no additional coverage of the restaurant on that date. The detail appears in her opening, delivered to the jury with the specific authority of someone who saw it, or who was told by someone who saw it, and you cross-examined the informant for 2 full days, and the noise from the kitchen never appeared in his account. That detail lived in Hennessy's opening statement and nowhere else in the public record of the proceeding. You filed no motion to inquire into it. There was no procedural mechanism to compel an answer. It remains, 23 years after the verdict, a sentence in an opening statement that you heard in a courtroom in 1986 and have not been able to place inside a clean explanation. Patricia Hennessy is now a federal judge. You have appeared before her 4 times since. 6. The thing you were asked to do that you didn't do. The room you just walked into. It is 1988, and you are at dinner, not a meeting dinner, a restaurant with tablecloths and a wine list and other tables occupied by people having ordinary evenings. And the man across from you is not a client in any documented sense and has never signed a retainer agreement with your firm, but whose interests you have on 3 occasions advanced through attorneys who were formally retained, which is a structure that exists in a legal gray zone the width of a highway. He orders fish. You order the same thing you always order here, which is a particular inefficiency of habit that you've never corrected because the dish is good. He waits until the server has gone and then he tells you, in language that is so indirect it requires active translation, that a specific individual, a potential government witness in an upcoming proceeding, is experiencing a great deal of anxiety about his situation, and that it would be beneficial if someone were to reach out to this individual and help him understand his options. He cuts his fish. He looks at the table. He looks at you. What you noticed. The potential witness is a man named Gerald Foote, and his name has appeared in a proffer session summary that your associate found in the discovery materials from a related case. And you know, because you are very good at this, and being very good at this is the reason this man is having dinner with you, that Foote's account, if accurately represented in the proffer summary, is damaging but not fatal to the matter in question. You know what the man across the table is asking you to do. He is not asking you to call Foote. He would not ask you to call Foote directly. He is asking you to know someone who knows someone who might have a conversation that would help Foote understand his options. The specific legal term for this is witness tampering. The specific penalties, under the relevant federal statute, include a sentence that could comfortably exceed whatever sentence the underlying client is facing. You eat a piece of bread. You put the bread down. You tell him that you are going to speak very directly, and that what he is describing is not a thing you do, and that if he would like to discuss lawful strategies for addressing the evidentiary weight of Foot's potential testimony, you are available for that conversation at your billing rate. He nods. He picks up his fork. He eats his fish. The detail no one at that table could answer cleanly was whether the nod was agreement or acknowledgement. What got out and what didn't. No account of this dinner appeared in any public record. The restaurant has since closed. The man across the table was never charged with any offense related to witness tampering in the matter in question. Gerald Foote testified at the subsequent trial, and his testimony was, as you had assessed, damaging but not fatal. The defendant was convicted on 2 of 7 counts. In the years following the trial, one journalist who covered organized crime for a metropolitan daily described, in a book published in 1997, a dinner meeting at an unnamed restaurant between unnamed parties in which a certain kind of request was made and declined. The journalist did not identify the parties. He described the dinner as emblematic of a specific professional boundary that existed, in practice, along a contested line between what the law prohibited and what the culture expected. How it was closed. No formal proceeding, investigation, or inquiry was initiated regarding the events described. The dinner was not documented in any law enforcement record known to have been produced in subsequent proceedings. The witness testified. The trial concluded. The relevant matters were docketed and closed in the ordinary course of judicial administration. The professional relationship between the parties to the dinner continued, in altered form, for several years following the meal. The thing that doesn't close. And yet you went back to that restaurant. Not that night. That night you paid the check and took a cab and went home and poured 2 fingers of whiskey and stood at your kitchen window until the light changed, but you went back. 3 weeks later, because the food was good and the table by the window was the right distance from the other tables, and because not going back would have meant something, would have been a concession to the weight of the evening, and you had spent 15 years learning not to make concessions to weight. You ordered the same thing. You sat at a different table. Across the city, across the 5 boroughs, across the federated system of professional relationships and organizational affiliations and retainer agreements that constitute the architecture of this world, there are perhaps a few dozen men who have had a version of this dinner. Of that number, some unknown proportion said yes. You said no. The distinction between those 2 populations is real and it matters, but both populations are still eating dinner. There are 5 entries left. By the time we reach number 1, you will not be at the table. You will be the table, the surface on which the choices were made. And that is a different kind of weight than anything we've covered so far. 5. When a client disappears. The room you just walked into. It is the morning of October 14, 1991, and your client has not appeared for his 9 o'clock arraignment, and the judge is looking at you in the way judges look at defense counsel when they want to make the defense counsel's situation very clear without saying it plainly. You are standing at the podium. Your associate is to your right and slightly behind you. The AUSA is at her table and she is not smiling, but there is a quality of arrangement in her posture, the specific arrangement of someone who is watching what they expected happen, that carries its own information. Your client's name has been called. Your client is not here. You tell the court you have been unable to reach your client this morning, and that you are requesting a brief continuance to determine his whereabouts. The judge grants 30 minutes. You step into the hallway and you call the 3 numbers you have for your client and you reach no one. And then you stand in the marble hallway of the federal courthouse, and you understand, without being told, that the 30 minutes will not resolve this. What you noticed. Your client is a man named Anthony Sella, and he has been your client for 6 years, and in 6 years he has never missed an appearance by so much as 5 minutes. That is the first fact. The second fact is that his bail conditions included electronic monitoring, and the monitoring unit, you will learn when your associate makes the call, transmitted normally until 11:17 the previous evening, at which point the signal ceased. Not the unit. The unit was found, later, in a dumpster on a street in Queens. Just the signal. The third fact is that the indictment Sella was arraigned to answer is connected to a case in which two witnesses have, in the preceding 8 months, revised their anticipated testimony in ways that were favorable to the government. The judge calls the case again. You walk back through the courtroom door. You tell the court you have been unable to locate your client and request that the court note your good faith efforts. The court notes them. The court issues a bench warrant. The courtroom deputy writes something down. The detail no one in the room could answer cleanly was whether Anthony Sella was alive. What got out and what didn't. The bench warrant was a public record. The press noted Sella's failure to appear and the issuance of the warrant in a short item that described him as a fugitive. An FBI bulletin was circulated to field offices in the relevant jurisdictions. What the official record contained was an account of a man who had fled rather than face trial. What people in proximity to the relevant organizational structure understood, and what the FBI's organized crime unit, based on intercepted communications from that period, also understood but could not prove, was that Sella had not fled. Sella had been moved. The distinction between a man who runs and a man who is removed is a distinction that matters a great deal, and that the public record in this case did not draw. How it was closed. The bench warrant remained active. Anthony Sella was entered into the National Crime Information Center database as a fugitive. The indictment remained pending. Periodic inquiries were made through appropriate channels regarding Sella's whereabouts. No confirmed location was established. The case remained on the docket in a status that allowed for prosecution to resume upon the defendant's apprehension. It remained in that status for a period that the court, in a later administrative review, described as extended. The file was not closed. In the absence of a body, the file cannot be closed. The file is still open. The thing that doesn't close. But you filed the motion requesting continuance on October 14, 1991. You stood at the podium. You made the call in the hallway. And the specific gravity of that morning, standing in the marble hallway of a federal courthouse, dialing 3 numbers, reaching no one and understanding, did not leave with the bench warrant or the NCIC entry or the FBI bulletin. You are, in the formal sense, still counsel of record in a case whose defendant has not been located. That is not a metaphor. That is a docket entry in the Eastern District that lists your name alongside the name of a man who has been absent from every record, every surveillance log, every informant account, and every organized crime intelligence summary for longer than some of your current associates have been practicing law. The file that cannot be closed is in a federal courthouse. Your name is in it. 4. The wire you didn't know about. The room you just walked into. You are sitting in your own conference room. It is 1994. The conference room has 12 chairs, a window that faces north, and a credenza along the west wall where your assistant keeps a coffee service that runs from 7 in the morning until 5 in the afternoon. This room has been the site of client meetings, strategy sessions, argument preparation, settlement discussions, and every other species of work that a criminal defense firm generates. You have sat in this room 10,000 times. Today you are sitting in it while 2 DOJ attorneys play you a recording, on a cassette player they brought with them, on a table in your conference room of a conversation that occurred in this room 14 months ago. The voices are clear. One of them is yours. What you noticed. The recording was made pursuant to a Title III wiretap order that was obtained by the government, and that targeted not the room itself. Rooms cannot be targeted under Title III in this configuration, but a device. The specific mechanism by which the recording was obtained is, the DOJ attorneys tell you, detailed in a sealed affidavit that they are not authorized to share. What they are authorized to share is the recording. They play 42 minutes of it. Your voice appears at the 15-minute mark and again near the end. What you say, both times, is consistent with the representation of a client specific, privileged, clearly within the scope of the attorney-client relationship. What the other voice in the room says, in the section between your appearances, is something else. The DOJ attorneys stop the tape. The younger one places a document on the table. The document is a proposed cooperation agreement. They are offering you something. That is when you understand that the recording is not a case. The recording is a door. They want you to open it. What got out and what didn't? Nothing about this meeting appeared in any public record. The existence of the wiretap order was sealed and has not, to date, been confirmed in any public proceeding. What emerged, years later, in the course of separate litigation in which the government's investigative methods in organized crime cases from this period were examined, was a reference to a category of recording operation that targeted professional offices adjacent to known organized crime figures. The reference was heavily redacted. What former federal investigators described, in background conversations with journalists who covered this era, was a program of what one called soft targeting, obtaining recordings from environments that were not the primary investigative target but that were frequented by individuals of interest. Your conference room was, in this framework, not the target. It was the environment. How it was closed. You declined the cooperation agreement. Your attorney, you retained outside counsel that afternoon, for the first time in your professional life, filed a motion challenging the lawfulness of the recording. The motion was argued in closed session before a federal magistrate and was ultimately resolved through a sealed order whose contents you are not at liberty to discuss. The DOJ did not bring charges. The cooperation discussion was not revisited. The cassette player was taken back when the attorneys left. The recording, as far as you know, exists somewhere in a federal evidence repository under a case number you have never been given. Your name is associated with it in a file you cannot access. The thing that doesn't close. But your voice is on a tape. 2 appearances, at the 15-minute mark and near the end, saying things that are entirely lawful and entirely consistent with the representation of a client. And those appearances bracket 42 minutes of material you cannot contextualize because you were not in the room for all of it. Someone else's voice is in that recording. You do not know what it says in its entirety. You know what the DOJ attorneys chose to play for you. And the gap between what exists on that tape and what was played for you in your own conference room, on a machine they carried in and set on your table, is a gap you have no mechanism to close. The sealed order is sealed. The case number is withheld. Your voice is on a tape in a repository, and you are listening to it from the outside, across 30 years, and you cannot hear the parts they chose not to play. 3. The conversation in the car. The room you just walked into. There is no room. That is the point. It is 1997, and you are in the back seat of a car, not your car. A car that was sent for you, and the man beside you is the closest thing to a principle that this world has produced in the past 20 years, and he does not meet in offices, and does not meet in restaurants, and does not appear on any organizational chart that any law enforcement agency has publicly confirmed. The car has been moving for 11 minutes. You know this because you checked your watch when you got in. The partition between the back seat and the driver is closed. The windows are tinted. The man beside you is not a client of yours in any documented sense. He is asking you about a case you are formally retained on, involving an individual 3 steps removed from him in an organizational structure that the FBI's chart, which you have seen in discovery materials, maps in a specific direction. And he is asking you about it with the patience of someone who already knows the answer and is asking to learn something about you from how you give it. What you noticed. The car is a town car, black, 4 doors, interior in good condition but not new. The driver has been driving for 11 minutes without a turn, which means you are on a highway or a highway-adjacent road. You cannot see enough of the outside to place yourself precisely. The man beside you is in his late 60s. His hands are folded in his lap. He asks his question about the case in 3 sentences, and the third sentence contains a detail about the case that is not in any public filing and is not something you told anyone outside of the attorney-client relationship. You feel that detail the way you feel a change in air pressure, not dramatically, just as a physical fact, a shift in the quality of the air in the back seat. You answer his question. You answer it honestly, to the extent that honesty is available to you in this configuration. You tell him what you can tell him about the case's trajectory. He nods. The car does not slow down. The detail that nobody in that car, including you, can answer cleanly is how he knew the thing he knew and what it means that he told you he knew it. What got out and what didn't. Nothing about this conversation appeared in any record. No surveillance asset placed you in that vehicle. No informant's account described the meeting. What appeared in the FBI's intelligence summary for the relevant period was a notation describing certain defense strategies in the connected case as unusually well-informed regarding government investigative priorities, which is the institutional language for something that the official record cannot directly characterize. Your conduct in the connected case was lawful. The case outcome, a hung jury, followed by a retrial that ended in acquittal on the primary count, was lawful. The acquittal was the result of the lawful application of the rules of evidence and the standard of proof. Nothing about the car is in any of those records. How it was closed. The car ride lasted 23 minutes in total. You were returned to within 2 blocks of your office. You walked the 2 blocks. You took the elevator to the 14th floor. You had a 3 o'clock meeting with an associate about an unrelated matter. The 3 o'clock meeting is in your calendar. The 23 minutes before it are not. The thing that doesn't close. And yet the detail he knew, the specific detail from inside the attorney-client relationship that had no business being in his possession, is something you have been carrying for 27 years. Not because it implicates you. You have examined it from every angle and the examination comes back clean. You did not disclose it, and no one to whom you disclosed it within the proper scope of the representation had reason or opportunity to pass it along, which means it moved through a different channel. Which means there is a channel you cannot see. A man in the back seat of a car knew something he should not have known, and the knowing was not threatening and was not a demonstration. It was just a fact, offered in the middle of a 3-sentence question, the way you mention something in passing when you want the other person to understand the scope of your visibility. Across 27 years in 4 states and every major organized crime proceeding in which you have been involved since, you have never identified the channel. The car keeps moving in your memory, on a road you cannot place, with a man whose hands are folded in his lap. 2 entries left. What you've built over 30 years, the practice, the retainers, the conference room, the verdicts, the careful, precise understanding of what goes in the file and what goes in the pocket, all of it arrives now at the only 2 questions that were ever going to matter. 2. The moment you understood what you were. The room you just walked into. It is 2002, and you are in your office alone at 11 at night, and on your desk there is a grand jury subpoena, a draft motion to quash, and a legal pad with 17 pages of notes in your handwriting, and you are looking at the window, not through it, at your own reflection in the dark glass, and you are doing the arithmetic. Not the legal arithmetic. You have done that. The motion has a reasonable probability of success on the privilege grounds, and even if it doesn't fully succeed, the scope of compelled production can be narrowed to a range that is manageable. That arithmetic resolves. The other arithmetic, the one you are doing at 11 at night, alone, looking at your reflection, does not resolve in the same way. You have been practicing for 28 years. In those 28 years, you have represented 41 individuals who were formally designated by the FBI or DOJ as members or associates of organized crime families. Of those 41, you have obtained full acquittals for 9, partial acquittals or reduced charges for 22, and unfavorable outcomes for 10. The math is good. The math is very good. The math is the problem. What you noticed. The legal pad has 17 pages because you started at 8 and you don't stop until the argument is complete. Your pen is a particular brand. You have used the same brand for 20 years, bought in boxes of 12, kept in the credenza drawer, and the pen is nearly out of ink, which means you've written enough tonight that the argument is close to finished. The window reflects a man in a good suit at a good desk, in an office with a window that catches the morning light. The 9 full acquittals. Those are people who are alive and free and, in some cases, continuing to operate in ways that the legal system has been unable to interrupt. You obtained their freedom. That was your job and you did it well and it was lawful and the system is designed to function this way. The adversarial system requires the best possible defense, and without it the prosecution is unchecked, and an unchecked prosecution is a danger to everyone. You believe this. It is not a rationalization. You believed it at 31 and you believe it at 59, and the belief is real and the belief is insufficient, and both of those things are true in the same moment. You put the pen down. The detail no one in the office could answer, there is no one in the office, is whether the arithmetic of 28 years is a record or a ledger, and whether the difference between those two things matters at 11 at night, alone, in a good suit, looking at your own face. What got out and what didn't. Nothing of this evening appeared in any record. The motion to quash was filed the following morning and is a matter of public record. Its arguments are cogent, well-researched, and grounded in settled precedent. What the motion does not contain is any account of the 17 pages, or the pen running out of ink, or the reflection in the window. The public record of your career is a sequence of lawful representations, competently executed, producing results consistent with the highest traditions of the criminal defense bar. Several Bar Association publications have noted your record in federal court. A profile in a legal trade publication, published in 1999, described your practice as a model of rigorous advocacy within the most demanding conditions that the adversarial system produces. The profile is accurate. The profile is a photograph of the surface. How it was closed. You finished the argument, you capped the pen, you turned off the desk lamp, you took the elevator down and walked to your car in the parking structure and drove home and went asleep. In the morning you filed the motion. The motion was, as calculated, partially successful. The scope of compelled production was narrowed. The representation continued. The career continued. The window in the office continued to catch the morning light. The thing that doesn't close. But the nine full acquittals, you know their names. You know what they were charged with. You know what the government believed they had done, not as a matter of proven fact, because the jury said otherwise, and the jury was right to say otherwise given the evidence presented, and the evidence presented was what the system produced, and the system is what it is. You know all of that. And you also know that 9 men walked out of federal courtrooms because of what you did, and that walking out of a federal courtroom is not the same as being innocent, and that being not guilty is not the same as being innocent, and that the system knows this and was designed to accept this as the cost of protecting the genuinely innocent from the power of the state. You accept it too. You accepted it at 31. The acceptance is real. And there are 9 names on a list in the back of your memory that you have not written down anywhere, and you know each one. And knowing them is the specific weight that 28 years of lawful practice deposits in a person, and it does not appear in the motion, and it does not appear in the profile, and it does not appear in any record, and it is the only record that you carry. 1. The last retainer. The room you just walked into. It is 2009. You are 66 years old. You are in the client chair in your own office. You move to the client chair because your back has been bad and the angle is better, and across from you in the chair where clients sit is a young man. He is 29. His suit is new but his shoes are broken in, which tells you something about where his money has been going and where it recently started going. He has a name that you will not repeat here. His father's name you know. His grandfather's name you know. You represented his grandfather twice, a long time ago, in a different century in every sense that matters. The young man slides a retainer proposal across the desk. He has prepared one, which is unusual for a first meeting and means someone coached him, and he tells you that he has a matter that requires, in his words, someone with your history in this area. He is 29. He has a prepared retainer proposal. He has his grandfather's eyes, which is not a sentimental observation but a specific one. His grandfather had a particular way of watching a room while appearing to watch only the person in front of him. The young man has the same quality. It is not learned. It is the kind of thing that moves through families in the structure of the face. What you noticed. The retainer proposal is for an amount that, in 1974, would have required a second trip to the clerk's window. In 2009, it represents 3 months of operational overhead for your firm, which is smaller now than it was in 1984, 2 associates, the paralegal, the receptionist who still uses the specific tone when she calls back to warn you. You pick up the proposal. You read it with the same attention you have given to every document that has passed through this office for 35 years. The matter is a federal investigation, early stage, no indictment yet, the phase where the right representation can shape the outcome before the shape is set in the government's mind. This is work you know. This is the specific work that you are, by any honest assessment, among the best in the country at. The young man's grandfather walked out of a federal courtroom in 1976. You were second chair. You handed documents. The young man places his hands flat on the desk, the way his grandfather placed an envelope flat on a desk, and he waits. The detail no one in the room can answer cleanly is what you are going to do with the proposal. You are the only one in the room who doesn't know. What got out and what didn't. Nothing of this meeting has appeared in any public record. Whether a retainer was signed, and whether the representation that followed produced a docketed proceeding, is not information this account contains. What exists in the public record is a career, 35 years, a sequence of representations, a list of case outcomes that any defense attorney in the country would recognize as the record of someone who understood this work at a cellular level. What exists outside the public record is everything else. The 17 pages, the car, the conference room, the coffee mug left 3/4 full on a desk in a facility you never entered again, the 9 names, the sticky note folded once, disappearing into a jacket pocket. How it was closed. This entry has not been closed. It is not possible to close an entry that has not resolved. You are in the client chair. The proposal is in your hands. The young man has his grandfather's eyes. The morning light is coming through the window the way it has come through the window for 25 years. The pen in your jacket pocket is the brand you have used for 2 decades. None of these are metaphors. They are the physical furniture of a decision you are in the process of making. The thing that doesn't close. And yet you know, sitting in your own client chair with a retainer proposal in your hands, that the decision has already been made. Not this morning. Not when the young man walked in. The decision was made in 1974 in the bail hearing when you took the sticky note and did not ask what the charge was. Every representation since has been an extension of that first extension of yourself. Lawful, defensible, excellent, and cumulative in a way that no individual representation reveals and that all of them, assembled, make plain. The young man is waiting. He has been coached to wait quietly, which is itself a form of argument. Across 35 years, across 4 jurisdictions, across the full federated architecture of clients and retainers and grand juries and car rides and conference rooms and verdicts, you have been the man who makes them untouchable. Not by doing anything unlawful, by doing the lawful thing with a precision and a consistency and a specific quality of intelligence that the system could not build a case around. That is the job. You were good at the job. You are still good at the job. The question, the one in the client chair, with the morning light coming through the window, with the young man's grandfather's eyes watching you from across the desk, is not whether you are going to take the retainer. You are going to take the retainer. The The question is whether the man who takes it is the same man who went home in 1974 and looked at the ceiling and said quietly to no one, "I can do this." Or whether 35 years of doing it have produced a different man entirely. One who no longer needs to say anything to the ceiling, because the ceiling already knows. You pick up your pen. You begin. If you made it to the end, if you stayed in the chair for the whole thing, then you know what this channel is. We don't narrate from outside. We put you in the room and we let the room do the work. Subscribe if that's where you want to keep living. Every story on this channel is built the same way. You are never watching. You are always already inside.